Please come to 119. Lord, this is Hindu Marriage Act, which the same parliament, the same legislature, using some word, my lord, in different statute is presumed to know the same meaning. Lord, section 5(3), Roman 3. The bridegroom has completed the age of 21 years and the bride the age of 18 years at the time of marriage. Lord, same section 3, bridegroom and bride. Then your lordships may only see, my lord, punishment for bigamy. Or please see, my lord, section 19, item number 8, court to which the petition shall be presented. 3A. In case the wife is the petitioner, where she is residing on the date of presentation. Your lordships may, my lord, come next, my lord, page 121, PDF 121. I am skipping rest, my lord. Hindu Adoption and Maintenance Act, my lord, applies to me. I can adopt, my lord, if I have married a Hindu wife. If I marry Hindu wife, my lord, under the Special Marriage Act, Hindu Adoption and Maintenance Act would apply. Section 12, capacity of a male Hindu to take in adoption. And 13 is capacity of a female Hindu to take in adoption. You'll have to necessarily be having different eligibility to adopt a child. Because if it is man, he cannot adopt a girl child less than 21 years of difference. If it is a female, she cannot adopt male child. So it can never become gender neutral. Then, my lord, 15 is maintenance for wife. 16, maintenance of widowed daughter-in-law by the father-in-law. Lord, suppose in a same-sex couple, one of them dies and the other claims against the father-in-law that in our relationship, I was the daughter-in-law. I was the wife and therefore your daughter-in-law. Impossible, my lord, to decide that fact. That is something, my lord, in abstract, no court can decide that. It has to be, my lord, a biological woman or a conventionally known biological woman, my lord. Then dependents are also defined in 17, my lords. A, from the estate of her husband, and B, from her son or daughter, if any, or his or her estate. Then, my lord, Hindu Succession Act. Your lordships have, my lord, indicated already, I am not reading it. If a female Hindu dies without making a will, there is a separate list of succession. Class 1, Class 2, agnates, cognates, but Class 1, Class 2 changes. And this is, my lord, applicable under Section 21A of the Special Marriage Act. There is no dispute. If a male Hindu dies intestate, then there is a separate list provided. But there also, if a male Hindu dies intestate, wife is in Class 1 heir, widow is in Class 1 heir. Whether in case of a same-sex couple, one of them dies, the second can claim as a widow or not. Hindu Succession Act will have to be, my lord, suitably amended. Then natural guardian, my lord, Hindu Minority and Guardianship Act applies because of 21 Act. If both are Muslim, both are Hindus, both married people are Hindus. Kindly see A. The natural guardian of a Hindu minor in respect of the minor's person, as well as in respect of minor's property, excluding his or her undivided interest in the joint property are, in case of a boy or an unmarried girl, the father, and after him, the mother. So you'll have to decide who is the father. There is no difficulty as of now because it is not tried to be made gender neutral. And we know father means a particular attribute, mother means a particular attribute. Similarly, my lord, your lordships can, my lord.
Solicitor,
please, your lordship.
To test it as a devil's advocate,
yes,
can it be said that under all these provisions, the biological sex at birth is what is to be taken into account, as the purpose is only to facilitate a marriage of a gay couple? Can it be said? I'm putting a question to you.
Yes, my answer is this, my lord. First of all, if we go by the intent and purpose of the legislature, the intent and purpose is that the legislature always thought of biological conventional man and biological conventional woman in consideration. Second, even if it is ignored, Lord, it will not become workable for the simple reason that when it says that widow will inherit, in same-sex gay couple, who will be the widow? They may say that I'll not claim, but all same-sex couples are not here. They cannot waive their right on behalf of the entire community. And it can never be decided on a case-to-case basis, my lord.
Could be dependent on the other.
Yes, completely, my lord. And court also cannot decide, my lord, if someone dies.
Yes, please.
Yes, Mr.
Yes. Look, these are all interlocked laws. Lord, personal laws are interlocked. It's like a jigsaw puzzle. You can't remove one block and Lord, replace it with something. Then the entire picture changes.
So you want us to see any other statutes here? That's it. There.
Yes, I'll just give illustrate. This is again an illustrative list, not an exhaustive list.
Right. The next now is your Hindu Minority and Guardianship Act.
Guardianship Act, Lord.
Muslim Women Protection of Rights.
Kindly, my lord, see the last section 29 on that, my lord, at
20.
page 125. Section 6, custody of minor children. This is for Muslims. Again, my lord, man, woman, but kindly see 29. Notwithstanding, and I'm sorry. Anything contained in any other law for the
125.
I'm sorry. Yes. PDF 125.
Yes, we got to.
Yes,
Section 29 of
right.
Muslim Women Protection of Rights on Marriage Act 2019. 29. Notwithstanding anything contained in any other law for the time being in force, a married Muslim woman shall be entitled to custody of her minor children in the event of pronouncement of talaq by her husband in such manner as may be determined by the magistrate. So the custody goes to mother. It will have to be decided who is mother. And mother means the way we understand, the way Parliament has understood. Then your lordships can keep Parsi Marriage Act again. Parsi man means husband and Parsi wife means woman means wife, etc. Christian Marriage Act, similar provisions. But please come to 129.
You know, Mr. Solicitor, talking of the Parsi Act, I mean, just as an aside, this is probably the only act where there's a jury trial.
Yes.
So as single judges of the High Court, and I've sat presiding over a jury trial in a Parsi matrimonial dispute. So you have jurors who will advise you on the on facts. And most of these trials, you're very distinguished members of the community who come and attend and take their work extremely seriously. You might have a top surgeon in the city who has decided
They
to
come
give
as
that one
jury
day.
members.
They come and sit and as jury members in the.
Lord, please come to page 129. I'm just, my Lord, I'm not reading all. Please, my Lord, read it at leisure. I have highlighted that part which is, my Lord, making it impossible to reconcile, my Lord, if the way they want the Special Marriage Act to be read is in fact read. So section 57. My Lord, this is Christian Marriage Act. Separated wife deemed spinster with respect to after acquired property. The spinster and bachelor has its own meaning, my Lord.
Highly objectionable. This language needs updating.
Mr. You have to amend the act, Mr. Solicitor.
My Lord, this is,
Spinster
your Lordships are right,
and
1872. 1872.
Time to update ourselves.
Your Ladyship, my Lords are right.
Deemed spinster.
Then, my Lord, your Lordships, my Lord, kindly come to Lord, page 139, Dowry Prohibition Act. But, my Lord, that is read, my Lord, that both can invoke. No, I'm sorry, Domestic Violence Act is, my Lord, can be invoked by both.
Yes, that's important.
139.
139.
Yes. Penalty for giving or taking dowry. Please see, my Lord, 2A. I'm not reading the whole because it's not necessary, your Lordship.
No.
You come to the domestic.
That's at PDF 137.
No, my Lord, 139, my Lord, if your Lordship.
39 is dowry.
139 is
37.
dowry.
Yes, Dowry Prohibition Act.
We thought you were referring to the
I think you
domestic.
please turn to 137.
7. DV Act.
DV Act.
Yeah, yes.
Please.
134.
Lord, but DV Act, my Lord. Aggrieved person means any woman who is or has been in a domestic relationship with the respondent and who alleges to have been subjected to any act of domestic violence by the respondent. The respondent means any adult person, it can be father-in-law, etc., brother-in-law, any adult male person who is or has been in a domestic relationship with the aggrieved person. Lord, I did not read this because possibly, Lord, this court had, my Lord, a
No,
year
but
or
then,
two.
see, look at the proviso. So that
Proviso is
proviso
aggrieved
is
wife or
for
female living in a.
relative of the husband
Living in a
or of the male partner. Therefore, that's where the sisters, I mean,
Mostly that's the-
surviving sisters-in-law, and mothers-in-law, they all come in like.
All are coming, and even brother-in-law,
Yes.
uh,
relative.
So the proviso expressly applies to a heterosexual relationship.
only. Yes. And my lord, Dowry Prohibition Act, my lord, 2A. Nothing in subsection 1 shall apply to or in relation to presents which are given at the time of marriage to the bride without any demand. And my lord, then it says bridegroom without any demand. So again, my lord, what is contemplated is heterosexual couple.
What is the Dowry Prohibition Act?
Page
Page
138.
138.
Lord, 139, my lord. 138, I'm sorry.
Which provision was solicitor reading? Mr. Solicitor,
Lord,
which
106, section 1, Lord, item 106, section 3 of the Act, 2A. Your Lordship gets, my lord?
marriage to the bride.
Nothing in this subsection 1 shall apply or in relation to 1A, presents which are given at the time of marriage to the bride without any demand having been made in that behalf, provided that such presents are entered in a list maintained in accordance with the rules made under this Act. Presents which are given at the time of marriage to the bridegroom without any demand having been made in this behalf. So they also, my lord, mention bride and bridegroom. My lord, kindly now turn to, my lord, just as an illustration, my lord, Indian Penal Code. Man and woman are defined under section 10, my lord, 140 at the foot. Section 10. Lord, your lordships, man, woman, the word man denotes a male human being of any age. The word woman denotes a female human being of any age. Then 114, my lord, for example. And my lord, when 1954 Act came, this definition was in existence. The legislature knew what is the meaning of male and female. Well, then section 100 and well, item 114, section 304B, where the death of a woman is caused by any burns or bodily injury or occurs otherwise than under normal circumstances within 7 years of her marriage, and it is shown that soon before her death she was subjected to cruelty or harassment by her husband or any relative of her husband, or in connection with any demand for dowry, such death shall be called dowry death, and such husband or relative shall be deemed to have caused her death.
So suppose a lesbian woman in a relationship.
Even 376 will not apply in the case of same-sex couples who are males.
My lord, 375, if your lordship sees at page 142, it applies only to males. And please see, my lord, I will not read. A man is said to commit rape.
142, is it over here?
Yes, my lord, page 142, section 375, definition of rape. Because only man can be guilty of this offense, my lord.
A man is said to commit rape.
And further, my lord, a man is said to commit rape if he so and so.
Right. I meant something else. Mr. Solicitor. If a man, and here I'm not talking of same-sex relationship. If a gay man rapes another man, it is not rape.
IPC, this is that.
That would be 377,
7.
which is, my lord, now which goes.
Of course. No.
No.
Without consent is there. Yes.
But then
Still consent 377.
Yes. It is. I stand
I
corrected.
think there is a change in there's a difference in the
Expression.
of course definition, but even the penalty also.
Yes. Your lordship, it's only consenting same-sex people. of any man. Yes.
It's 10 years. And all the other, amended provisions which have enacted gang rape,
Some women,
370 on women.
Right.
Now, there can be equally same situations on men
men
also.
also.
They are completely, inapplicable.
But in case of lesbian marriage, my lord, possibly this may not apply. Possibly. No, my lord, it may apply if we read man to be woman.
Disparity.
375 B.
Right. Definitionally, it is.
B. If we read man as woman also, then it may apply. Otherwise, the intention is to punish man. That's how it.
Was a definition of.
Yes. Otherwise, a woman can be guilty, my lord, under B or maybe under C. Not similar is abatement provisions, abatement to suicide under the Evidence Act. If a woman commits suicide, there is a presumption against the husband.
Right.
So again, my lord, we will have to see, my lord, who the person is. But the major problem is in Code of Criminal Procedure. My lord, page 144. Arrest how made. My lord, take a homosexual couple, both man, but one playing the role of a woman. Arrest of how made. Save in exceptional circumstances, no woman shall be arrested after sunset and before sunrise, and where such exceptional circumstances exist, the woman police officer shall, by making a written report, obtain the prior permission of the judicial magistrate of the first class within whose local jurisdiction the offence is
Because in
committed.
a case of a what else, Mr. Solicitor, now after
Yes,
16
Lord.
years?
Lord, last, Lord, I am not taking your lordship, Lord. I have given 160 such similar provisions, my lord. But, my lord, if your lordships can come to 147, my lord. When it is decree and decree is to be executed, even under the Special Marriage Act, my lord, therefore I pointed out section 39A, that decree of judicial separation or will be executed as. There also, my lord, the word is female, male, husband, wife, etc., etc. My lord, I am not duplicating. Your lordships can, my lord.
I think we can conclude this part of the analysis.
My lord, there are, but again, my lord, even if illustrative list is 150 sections of various other statutes.
All
So therefore, my lord, in my respectful submission, your lordships may not give the meaning, my lord, which creates complications then solving the problem. My lord, maybe if Parliament considers appropriate, Parliament may, in its wisdom, my lord, provide for a comprehensive legislature. And as I have pointed out yesterday, wherever other legislative bodies have done it, they have suitably amended other allied laws as well.
All right. What is
Maybe
the
by the amending act or by one act, my lord, whichever.
now,
way.
what is the next point, Mr.
Now, my lord, next is Gaidan, my lords.
Next
Kindly
point?
come to page 78.
Getan, okay.
Gadan, Gadan.
Yes, yes.
Which page?
My lord,
Volume?
82.
The other part,
The same.
page 82.
कहाँ पर है गीता?
82 कह रहे हैं।
Lordships need not read.
Yeah.
Page,
82.
I'm sorry.
Same note one.
Note at this stage, your Lordships need not read. I am also not reading. Page 63 to 82, I have produced relevant parts of the judgments which says that in the process of interpretation, your Lordships would not interpret contrary to the intent, would not change the structure, would not tamper with the architecture, etc., etc. These are the
Right.
propositions are well settled. I'm not, but these are the page numbers.
You
Now,
also
please,
quoted Lord Nichols.
yes,
Quoted Lord Nichols
yes.
extensively.
Extensively, my lord. Because that still continues to be a leading judgment on, my lord, how, where the process of interpretation ends and where the procession of legislation begins. Lord, 78. Lord, I'm sorry, page 82, PDF 82. Lord, the significance is, please, my lord, consider this. In Britain, your lordships are aware the House, Parliament is sovereign, it's supreme. There used to be no judicial review the way we understand it, to declare a provision to be unconstitutional. What they do is non-compatible, incompatible. That's how, my lord. That was introduced, my lord, by way of Human Rights 1998 Act. Gadan, my lord, in my respectful submission,
Yes.
yes, my lord, kindly, my lord, allow me to read this, my lord, Gadan, because the reliance is misplaced. Without giving the background and the context. Please see, my lord, further. Apart from the absurdities that the said principles as canvassed by the petitioner may lead to, it is necessary to also settle the issue raised through the judgment of Gadan. It is submitted that reliance on the said judgment is wholly irrelevant to the present case for the short reason noted as under. The system of judicial review in UK and the system of judicial review in India are starkly different. Prior to the enactment of Human Rights Act 1998, there was no judicial review of legislation in UK. Specifically, Section 3 of the HRA 1998 empowers the UK domestic court to reinterpret or force through treaty obligations under the European conventions in local statutes. In Gadan, the court was dealing with an entirely different subject matter of an enactment dealing with rent and not of creating a social institution in the nature of marriage. It was a question of a singular provision to be read in consonance with the treaty obligation and not the case wherein the entire architecture
Yes, please go.
Lord, Gadan was not dealing with, my lord, an interpretation which affected several multiple statutes. But now see the difference in powers available to the court, my lord, in UK and in India, my lord. A bare perusal of HRA, which for the first time in UK provided something akin to judicial review of legislation, would make it clear that the said legislation and our constitution operate very differently in terms of mode and the result it seeks to achieve. The relevant provision of HRA are as under. My lord, then 1 I can skip. Kindly directly come to 3 at page, my lord, 83. Interpretation of legislation. This is a kind of judicial review which is available, my lord, in UK, which is complete, my lord. Therefore, they say that Supreme Court of India is the most powerful court of the world, because your lordships can strike down the provision also as unconstitutional made by the competent legislature. Interpretation of legislation. So far as it is possible to do so, primary legislation and subordinate legislation must be read and given effect in a way which is compatible with the convention rights. But so far as it is possible, it's not a mandate of law. This section applies to primary legislation and subordinate legislation whenever enacted, does not affect the validity, continuing operation, or enforcement of any incompatible primary legislation, and does not affect the validity, continuing operation, or enforcement of any incompatible subordinate legislation if, disregarding any possibility of revocation, primary legislation prevents removal of the incompatibility. You declare it, nothing beyond that. It continues not only on the statute book, it continues to operate also. That, my lord, comes in further sections. Declaration of incompatibility. Subsection 2 applies in any proceedings in which a court determines whether a provision of primary legislation is compatible with a convention right. If the court is satisfied that provision is incompatible with a convention right, it may make a declaration of that incompatibility. Subsection 4 applies in any proceedings in which a court determines whether a provision of subordinate legislation made in exercise of power conferred by primary legislation is compatible with a convention right. If the court is satisfied that the provision is incompatible with a convention right and that, disregarding any possibility of revocation, the primary legislation concerned prevents removal of incompatibility, it may make a declaration of that incompatibility. A declaration of that, this section, under this section, a declaration of incompatibility, please mark, does not affect the validity, continuing operation, or enforcement of the provision in respect of which it is given, and is not binding on the parties to the proceedings in which it is made. It's kind of an advisory jurisdiction. It's, as they say, my lord, jurisdiction to nudge the legislature. And, my lord, I have also pointed out that after Gedan, even the courts in Britain have taken, my lord, different view, my lord. Now, your lordships may kindly see in Gedan, my lord, para 148, I have quoted Lord Nicholas. In this context, kindly read, my lord, my learned friend said that now after Gedan, whatever you want to read, you can read into the provision and even alter the statute. That was, my lord, the tall argument which was made, which is, my lord, how legally not sustainable, but the foundation is false. The foundation is that there is an equal jurisdiction between the Supreme Court of India and the UK Supreme Court. UK Supreme Court exercising power of declaring a statute to be incompatible, nothing less than that, my lord. Lord, 147, if your lordship don't mind, if your ladyship don't mind. 84, yes. My lord. It is submitted that despite the wide powers, the court in UK have clarified that the powers are limited, interpreting, not legislating. Even post-Gedan, we can only interpret, we cannot legislate. In considering that is what is possible, the courts have repeatedly stressed the constitutional importance of maintaining the boundary between interpretation, which is, Lord, this is in quotation, my lord, MacDonald judgment, subsequent to Gedan, interpretation which is a matter for the courts and others who have to read and give effect to legislation, and amendment which is a matter for parliament. This is post-Gedan MacDonald judgment. Now, Lord Nicholas in Gedan. Parliament, however, cannot have intended that in discharge of this extended interpretative function, the court should adopt a meaning inconsistent with the fundamental feature of legislation. This was not read before your lordships in Gedan, my lord, by the petitioner. In Rent Act, my lord, the essential feature is not whether the marriage is heterosexual or homosexual. It was rent and the provisions concerning that. That would be to cross the constitutional boundary, section 3(6) to demarcate and preserve. Parliament has retained the right to enact legislation in terms which are not convention compliant. The meaning imported by application of section 3 must be compatible with the underlying thrust of the legislation being construed. Words implied must, in the phrase of my noble and learned friend Lord Roger and Aylesbury, go with the grain of the legislation. My lord, in my respectful submission, this changes the scenario. In Special Marriage Act, grain of the legislation is heterosexual marriage only. Nor can Parliament have intended that section 3 should require courts to make decisions for which they are not equipped. There may be several ways of making a provision convention compliant, and the choice may involve issues calling for legislative deliberation. Then Lord Reger, my lord, your lordships may, my lords have, my lord, my lord justice, in same, my lord Gedan, my lord concurring. What excludes such provision from the scope of section 3(1) is not any mere matter of linguistic form in which Parliament has chosen to express the obligation. Rather, they are excluded because the entire substance of the provision, what it requires the public authority to do, is incompatible with the convention. The only cure is to change the provision, and that is a matter for Parliament and not for the courts. They, like everyone else, are bound by the provision. Gedan says this, which, my lord, was not assisted with, my lord, by the petitioner to your lordships.
Actually, you can see the last portion of that.
Lord, that
Page PDF 85. 85.
yes, my lord, 80.
The last
Yes,
highlighted.
what that is impossible. Yes, my lord. May I read, my lord, the first part also? It does not allow the courts to change the substance of the provision completely, to change a provision from one where Parliament says that X is to happen into one saying that X is not to happen. Then, my lord, bold portion at the foot of this para. For instance, the Court of Appeal held that I'm sorry. It was impossible for the court to use the interpretative obligation in section 31 in effect to recreate the fixed penalty scheme enacted by Parliament so as to turn it into a scheme that was compatible with Article 6. As Simon Brown, Lord Justice, observed, it would have involved turning the scheme inside out, something that the court could not do. Only Parliament, not the courts, could create a wholly different scheme so as to provide an acceptable alternative means of immigration control. This is the ratio of Gedan. Now, your lordships may allowed to kindly see para 149.
He uses stronger words like judicial vandalism.
My lord, I didn't read it, my lord. In fact, my lord, this is still, my lord, British language. American judgments are more harsher.
Very sharp.
Very sharp.
Very sharp, my lord. Very.
Because they are not always career judges, you see, in the American Supreme Court. They come from public policy backgrounds, from academia.
They use even sarcasm.
And justice judgments are extraordinarily trenchant.
Justice Kalia. Justice Kalia. Lord, Justice Kalia in this, my lord, Oberfläche has used sarcasm, my lord, while dealing with further judgment. But my lord, that
Writing that.
Yeah, absolutely.
Lord, para 149. Judicial vandalism, Lord, I avoided reading that part, my lord, but it's not, my lord, I'm just only reading, my lord. It is submitted that discussion of the boundary between legislation and interpretation has tended to focus on two factors. First, it will not be possible to construe legislation in a convention-compliant way if to do so would be inconsistent with some important feature of the legislation. The grain of the act, my lord, as they say. And grain is heterosexual, right from the debates till the language used. Secondly, the courts, even in UK, have shown a reluctance to place creative reliance on Section 3 in cases involving complex questions of social policy, which the courts are ill-equipped to decide and which are therefore best left to Parliament. The earlier authorities prior to Ghedan and after HRA, which were summarized by Lord Brigham in so-and-so versus so-and-so, it was held that a convention-compliant interpretation may not be possible where it would be incompatible with the underlying thrust of the legislation, or would not go with the grain of it, or would call for legislative deliberation, or would change the substance of a provision completely, or would remove its pith and substance, or would violate a cardinal principle of the legislation. My lord, this is before Ghedan and after the Human Rights Act, my lord, came into effect. Lord, kindly, my lord, come to the next page, my lord.
99.
Yeah, Ghedan was 99.
Gaidan was 99.
99.
So the Human Rights Act came into force in 1998.
98. And this judgment, my lord,
Gaidan is 2004.
no, Gaidan is 2004, I'm sorry.
2004. So it's after the
2004,
act.
my lord.
It's after the act.
It's post-act.
So between 98 and 2004 comes, my lord, this Sheldrake, Justice.
But the interesting part is that concurrently with Gaidan, you have that Civil Partnership Registration Act in 2004,
Four.
around that time. So there was a move there.
Yes, my lord, contemporary move. But that was discussed, debated in public, and thereafter brought by way of a legislature, my lord. And Ghedan was not concerned with that issue, my lord. On the subject matter before Ghedan was not that issue. Then, my lord, after Ghedan, Wilkinson judgment, my lord.
This
Yes.
is also very interesting.
May I, my lord?
We'll continue after.